State of Wisconsin versus Katie Koch, 23 CF 3129, appearances.
Mallory Davis appears for the state.
Attorney Brett Copeland appears in person on behalf of Ms. Cook, who appears in person in custody. Good afternoon, Judge.
Good afternoon, everyone. We are here today for a plea hearing. Are the parties ready to proceed with a plea hearing? State?
Yes, from the state.
Defense?
Yes, Judge.
State, do you have notice so that we may accomplish that then today?
Yes.
And state, what are the negotiations, please?
In exchange for the defendant's willingness to accept responsibility and admit to the facts set forth in the state's complaint, the state would move this court to dismiss and read in counts 4, 5, and 6. It would be the state's intent to combine the victims in count 3, which is false imprisonment. The state would also be seeking admissions to counts 1 and 2, both chronic neglect, consequences, emotional damage. So the defendant will be pleading to counts 1 through 3 as charged. Upon admission to the remaining counts, the state will recommend 20 years in the Wisconsin Department of Corrections, bifurcated into 10 years of initial confinement and 10 years of extended supervision. Defense would be free to argue all terms at sentencing. The state would leave conditions of extended supervision to the court.
Counsel, is that your understanding of the plea negotiations?
That is accurate.
And good afternoon, Ms. Cook. How are you?
I'm doing well, thank you.
Good. You've heard what the lawyers have said about what the plea negotiations are. Is
Yes.
that your understanding of the plea negotiations?
Yes,
That is, you would plead guilty to 2 counts of chronic neglect of a child, consequence is emotional damage, and 1 count of false imprisonment. The remaining charges in the information would be dismissed but read in for sentencing. And at another sentencing hearing, the state would recommend 20 years of incarceration in the Wisconsin prison system, bifurcated as 10 years initial confinement, followed by 10 years extended supervision. State would leave the terms of and conditions of extended supervision to the court, and your lawyer is free to argue for any sentence that you and he deem to argue for. Is that your understanding, ma'am?
yes, Your Honor.
Okay, very good. Let's talk about the charges that you're pleading guilty to then this afternoon. I will start with count 1 of the information. I'm sorry?
Sorry, I couldn't remember. I apologize.
No, that's okay. Count 1, chronic neglect of a child, consequence is emotional damage. In that, between July 13th, 2022 and July 13th, 2023, at 128 South 71st Street in the city of Milwaukee, Milwaukee County, Wisconsin, that you, being a person responsible for the welfare of a child, CJJ, date of birth April 30th, 2014, through your action, for reasons other than poverty, did negligently fail to provide necessary care so as to seriously endanger the physical, mental, or emotional health of the child, and the child suffered emotional damage as a consequence, and you are guilty of chronic neglect as you have committed 3 or more violations of child neglect within the time frame that's specified that we've talked about, that year from July 13th, 2022 to July 13th, 2023, contrary to law. That is your understanding, correct, ma'am?
Yes,
You understand that is a Class E felony for which you may be fined not more than $50,000 or imprisoned for not more than 15 years or both, correct?
yes, sir.
Count 2 of the information, chronic neglect of a child, consequence is emotional damage. In that, between July 13th, 2022 and July 13th, 2023, at 128 South 71st Street in the city of Milwaukee, Milwaukee County, Wisconsin, that you, being a person responsible for the welfare of a child, DMJ, date of birth September 24th, 2015, through your action, for reasons other than poverty, did negligently fail to provide necessary care so as to seriously endanger the physical, mental, or emotional health of the child, and the child suffered emotional damage as a consequence, and that this is chronic neglect as you have committed 3 or more violations of child neglect during the time frame specified here, that is July 13th, 2022 to July 13th, 2023, contrary to law. That is your understanding, correct?
Yes, Your Honor.
And you know that is a Class E felony for which you may be fined not more than $50,000 or imprisoned for not more than 15 years or both, correct?
Yes.
Count 3 of the information, false imprisonment, and that between July 13th, 2022 and July 13th, 2023, at 128 South 71st Street in the city of Milwaukee, Milwaukee County, Wisconsin, that you did intentionally confine CJJ without that person's consent and with knowledge that you had no lawful authority to do so contrary to law. That is your understanding, correct?
Yes.
You know that is a Class H felony for which you may be fined not more than $10,000 or imprisoned for not more than 6 years or both, correct?
Yes, ma'am.
Ma'am, do you understand that if you were to be sentenced to prison in this action, that you would have to serve in prison each day imposed as initial confinement time by the judge, because initial confinement time is not reduced by good time or parole?
Yes.
Okay. Part of the plea negotiations are that counts 4, 5, and 6 would be dismissed but read in for sentencing, and you've talked with your lawyer about what that means, correct?
Yes.
You understand that the court may consider the read-in charges when imposing sentence, but that the maximum possible penalty of the charged offense would not be increased, correct?
Yes.
You understand that you could be required to pay restitution as it relates to those read-in charges, right?
Yes.
And you understand that the state of Wisconsin is prohibited from future prosecution of the read-in charges, correct?
Yes.
Understanding all of that, do you agree the following counts may be dismissed but read in for sentencing? I will read them. That is, count 4, false imprisonment. Count 5, neglecting a child, specified harm did not occur. And count 6, neglecting a child, specified harm did not occur. May those counts be dismissed but read in for the purpose of sentencing, ma'am?
Yes. I'm sorry.
Okay, that's okay. Understanding everything that we've discussed then, Ms. Koch, what is your plea to count 1 in the information? Chronic neglect of a child, consequence is emotional damage, guilty or not guilty?
Guilty.
What is your plea to count 2 of the information? Chronic neglect of a child, consequence is emotional damage, guilty or not guilty?
Guilty.
What is your plea to count 3 of the information? False imprisonment, guilty or not guilty?
Guilty.
I have before me plea paperwork that your lawyer has filed entitled the Plea Questionnaire Waiver of Rights Form and the addendum to the Plea Questionnaire Waiver of Rights Form. They all appear to be electronically signed by you and your lawyer. The Plea Questionnaire Waiver of Rights Form appears to be signed on November 14th of this year, as well as the addendum. Did you review these documents with your lawyer on that day, ma'am?
Yes.
And when you were completed with that review, did you electronically sign these forms?
Yes, I did.
And when you reviewed these forms with your lawyer, was he able to answer any of the questions that you might have about what's contained on those forms?
Yes.
So do you understand then everything on the forms?
Yes, I do.
Are your answers to the questions on the forms and the information provided on them by you and your lawyer, is that all true and correct?
Yes.
At the time that you signed these forms, did you understand that you would be giving up the rights set forth on the forms by pleading guilty?
Yes.
In particular, when you plead guilty, you give up a variety of trial rights. I'd like to review them with you and ask you if you understand at the end, okay? All right. So when you plead guilty, you give up your right to remain silent and not incriminate yourself at a trial. Your right to see and cross-examine the state's witnesses. Your right to call witnesses and make them come to court and testify for you. Your right to testify at trial. Your right to have your case decided by 12 people sitting as a jury who would all have to agree in order to reach a verdict. Your right to have your case decided after a trial to the court, and your right to make the state prove you guilty by evidence beyond a reasonable doubt that you've committed the crime charged. You understand you're giving up those trial rights by pleading guilty, correct?
Yes, I do.
Okay. In order for you to be found guilty, it must be shown that you have committed acts that constitute the elements of the offense charged. To that end, your lawyer has filed a number of jury instructions. Those jury instructions list and define things about the crimes that they are about, the definition of the crime, the state's burden of proof, the elements that the state would have to prove if we had a trial. I see that your lawyer has filed the jury instruction for false imprisonment. Did your lawyer review that jury instruction with you, ma'am?
Yes.
And when you and your lawyer reviewed the jury instruction for false imprisonment, did you and he specifically talk about those 5 elements that would have to be proved if we had a trial?
Yes.
And your lawyer has filed the jury instruction for chronic neglect of a child, repeated acts of neglect. That lists the definition of that crime, the state's burden of proof, and the elements of that crime that the state would have to prove if we had a trial. Has your lawyer reviewed that jury instruction with you, ma'am?
Yes.
And when he did so, did he specifically talk about the things the state would prove as it relates to chronic child neglect?
Yes.
Okay. You also talked with your lawyer then about the criminal complaint and the information and all of the things about this case leading up to today, fair?
Yes.
Okay. Based on your review of these jury instructions and the elements of the crimes, based on your review of the criminal complaint and information and other documents you've gone over with your lawyer, and all of those conversations that you've had with your lawyer, Ms. Koch, do you believe that you understand all of the elements and things that the state would have to prove if we had a trial?
Yes, I do.
Very good. Ma'am, do you understand that the court is not bound by plea negotiations or by anything recommended by anyone at sentencing?
Yes, I do.
You understand that the court will hear the sentencing arguments of the lawyers. The court will hear from you and other people who may wish to address the court. The court will thoughtfully consider all of those things in crafting a sentence. But you also understand, ma'am, that the court is free to sentence up to those maximum possible penalties provided by law, correct?
Yes, I do.
Okay. Has anyone, including your lawyer, made any threats or in any way forced you to plead guilty?
No.
Outside of the plea negotiations in this matter, has anyone, including your lawyer, made any promises to you to have you plead guilty?
No.
Are you entering your plea freely, voluntarily, intelligently, and understandingly after having talked about these things with your lawyer?
Yes, I am.
Have you had any alcohol or drugs in the past 24 hours, ma'am?
No.
Are you prescribed medications at this time?
Yes, I am.
Are you taking them as prescribed?
Yes, I am.
Is there anything at all about those medications that you are taking as prescribed that would make it so you can't understand what we're doing in court?
No.
Anything at all about your physical, emotional, or mental health here today that would make it so you can't understand what we're doing here in court?
No, ma'am.
You're able to fully understand what's going on today?
Yes, I am.
Very good. And we've discussed the criminal complaint. I see that you've read it, and I know you talked with me about the fact that you've reviewed it with your lawyer, correct?
Yes.
So you understand what the criminal complaint says happened in this case, is that fair?
Yes.
Are the facts outlined in the criminal complaint substantially true and correct, Ms. Koch?
Yes.
Ma'am, do you understand that if you are convicted of a felony in this matter, that you will be prohibited from possessing a firearm in the future by state law, and that you will be prohibited from voting until your civil rights are restored?
Yes.
Do you further understand that if you are not a citizen of the United States of America, that a plea of guilty or no contest for the offense with which you are charged may result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law?
Yes.
Have you had enough time to go over this case with your lawyer?
Yes, I have.
Has your lawyer talked with you about what he believes are possible defenses to the charges?
Yes.
Has your lawyer talked with you about what he believes are mitigating circumstances with respect to the charges?
Yes, yes.
Are you satisfied that you have sufficiently discussed with your lawyer and that you understand the nature of the allegations against you, ma'am?
Yes.
Are you satisfied that you have sufficiently discussed with your lawyer and that you understand those possible defenses and mitigating circumstances that may exist in this case?
Yes.
Are you satisfied with your lawyer and the representation provided to you?
Yes, I am.
Are you at all confused about anything you're doing here today?
No.
Is there anything about this plea procedure that you do not understand or questions that you have for the court about the plea?
No.
And are you pleading guilty to chronic neglect of a child? Consequence is emotional damage as to CJJ, date of birth, April 13th, 2014. Chronic neglect of a child, consequence is emotional damage as to DMJ, date of birth, September 24th, 2015. And false imprisonment because you are guilty of those things, ma'am.
Yes.
Thank you, Ms. Koch. Counsel, have you gone over the guilty plea questionnaire, waiver of rights form, and addendum with your client?
I have.
Did you go over the elements of the offense with your client?
I did.
Are you satisfied that your client understands the elements of the offense and interrelationship between their conduct and the elements?
Yes, Judge.
Have you gone over the maximum possible penalties with your client?
I did.
Are you satisfied they understand them?
I do.
Have you gone over all possible defenses with your client?
I did.
Have you gone over all mitigating circumstances with respect to the charges with your client?
Yes, Judge.
Are you satisfied that your client understands those possible defenses and mitigating circumstances that may exist in this case?
Yes.
Are you satisfied that your client understands all of the rights they are giving up by entering their plea?
Yes, Judge.
And are you satisfied the plea is made freely, voluntarily, intelligently, and understandingly by your client?
I am.
Does the state consent to the jury waiver?
Yes.
The court approves the waiver and finds that Ms. Koch is entering the plea freely, voluntarily, intelligently, and with a full understanding of the nature of the charges, the maximum possible penalties, and all of the rights being given up by pleading guilty, and the court will accept your plea, ma'am. May I rely on the facts contained in the criminal complaint to form a factual basis for acceptance of the plea from the state?
Yes.
Defense?
Yes.
And so, ma'am, we've talked about that complaint, right? I know you've read it, you've gone over it with your lawyer, you know what it says. You told me the facts in it are substantially true and correct. May I use that document, the facts in the criminal complaint, to form a factual basis so that I can accept your plea here today?
Yes.
Very good, thank you. The court finds that there is a factual basis for the acceptance of your plea, and based on your plea of guilty, the court now finds you guilty of the offense of chronic neglect of a child, consequences emotional damage as it relates to CJJ, chronic neglect of a child, consequences emotional damage as it relates to DMJ, and false imprisonment in the manner and form as charged in the information. I adjudge you convicted on this date, and I order a judgment of conviction entered in the record. Pursuant to negotiation of parties, the following counts are dismissed but read in for the purpose of sentencing. Count 4, false imprisonment. Count 5, neglecting a child, specified harm did not occur. Count 6, neglecting a child, specified harm did not occur. All those counts dismissed, read in. We'll need to select a date for sentencing. I'll hear from the state as to anything else we need to address outside of sentencing.
The state would be seeking remand as it relates to this defendant.
And counsel, please, as to that request.
Judge, I would object to remand at this time. Ms. Cook has been in custody on a substantial cash bond that she's not able to post. I don't believe that's necessary.
I understand. All right, the state has moved for remand. I am remanding Ms. Koch pending sentencing. She is sitting on a substantial amount of cash bail. However, the state has requested remand that is governed by statute and is in the discretion of the trial court. I think given the totality of the circumstances here, that remand is appropriate, and so I will remand her pending sentencing. We'll select a date for sentencing. Anything else I need to do outside of scheduling that sentencing date, state?
No.
Defense?
No, Judge.
Very good. Author record to select that court date, please. Yes. And yes, exactly. That sounds like a good idea.
February 8th at 9 a.m.
how long are you setting this for?
I was gonna set it for 9 a.m. I was gonna set nothing after, and we will go until we're done.
So we could do one of two things. We can set it at 9 a.m. and go till we're done, or 2 and go until we're done. The nice thing about 9 a.m. is if we need to spill into the afternoon, we can. But we would give you the entirety of a morning or afternoon. I don't know how long you all think it may take.
The 8th at 9 a.m. is fine.
Is that a Thursday?
Yeah.
Yes.
Yeah, that's fine.
The next court date is February 8th at 9 a.m. for sentencing.
Thank you. We'll see you then.
Thank you, Judge.
Thank you. Feel better, Ashley.
Thank you. Great, I'm gonna be calling Mr. Matlock's case next.
Okay.
Sorry.
Ending the live stream.